This is Bloomberg Law with June Grasso from Bloomberg Radio.
Ryan's gender dysphoria was so severe that he was throwing up before school every day. He thought about going mute because his voice caused him so much distress. And Ryan has told the courts that getting these medications after a careful consultation process with his doctors and his parents has saved his life. His parents say he's now thriving, but Tennessee has come in and categorically cut off access to Ryan's care, and they say this is about protecting adolescent health. But this law harms Ryan's health and the health of all other transgender adolescents for whom these medications are a necessity.
At the Supreme Court today, the U.S. Solicitor General argued that Tennessee's ban on gender-affirming care for minors violates the Constitution's guarantee of equal protection. But Tennessee Solicitor General Matthew Rice argued that his state was protecting vulnerable children.
Tennessee lawmakers enacted SB 1 to protect minors from risky, unproven medical interventions. The law imposes an across-the-board rule that allows the use of drugs and surgeries for some medical purposes, but not for others.
Conservative justices like Chief Justice John Roberts and Justice Brett Kavanaugh expressed reluctance to get into the middle of the medical and policy debate by second-guessing the judgments of state lawmakers.
We may think that we can do just as good a job with respect to the evidence here as Tennessee or anybody else. But my understanding is that the Constitution leaves that question to the people's representatives rather than to 9 people, none of whom is a doctor.
So it seems to me that we look to the Constitution, and the Constitution doesn't take sides on how to resolve that medical and policy debate. The Constitution's neutral on the question. At least that's one way to look at it. I want to get your reaction to that. If the Constitution doesn't take sides, if there's strong, forceful, scientific policy arguments on both sides in a situation like this, why isn't it best to leave it to the democratic process?
Liberal Justice Sonia Sotomayor had this answer.
When you're 1% of the population or less, very hard to see how the democratic process is going to protect you.
Well, Your Honor,
you blacks were a much larger part of the population, and it didn't protect them. It didn't protect women for whole centuries.
Joining me is counsel for the transgender youth and families in the case, David Cole, a professor at Georgetown Law. He was most recently the National Legal Director for the American Civil Liberties Union. Thanks so much, David, for being here. What was your general impression of the oral arguments?
Well, it was a spirited argument. It was an argument in which I think a number of the conservative justices expressed concern about how they are supposed to review a judgment that involves medical, scientific evidence and uncertainty, but also where, there was really no good response to the contention, our contention, that the law discriminates on the basis of sex. It allows medical treatment if it is consistent with the sex that one is assigned at birth. It bars the treatment if it is inconsistent with your sex assigned at birth. When you tell someone that you can do something only if it's consistent with your sex, that is a sex-based classification. If you told people you can only pursue careers that are consistent with your sex, everyone would recognize that that's a sex-based classification. So while the court was concerned, some of the conservative members were concerned about the medical issues that underlie this case, the question in the case was simply, what is the proper standard of review, and is this actually sex discrimination?
It seemed to me like the liberal justices discussed that, but the conservatives stayed away from that issue. The Tennessee Solicitor General argued that it's not sex discrimination and that the law restricts the use of drugs based on medical purposes, not sex.
Yeah, that's what he says, but if you read the law on its face, you can get medical treatment if it is consistent with your sex assigned at birth. You can't get the same treatment if it allows you to live or identify inconsistent with your sex assigned at birth. And that is a sex classification. It is enforcing particular, sexual stereotypes on people. If you have a birth sex of male, You can get treatment if you want to masculinize, but you can't get treatment if you want to feminize. And the opposite rule applies to birth sex females. That's treating boys and girls differently by seeking to enforce gender conformity.
You referred to this, but a lot of the conservative justices kept saying, particularly Chief Justice John Roberts and Justice Brett Kavanaugh, that, we're judges, we're not doctors, let's leave it up to the lawmakers. They don't always leave it up to the lawmakers.
Right. You leave certain things up to the lawmakers, but you don't leave equal protection of the law up to the lawmakers. You don't leave constitutional rights up to the lawmakers. And those same conservative justices were quite willing and ready to review COVID regulations, which were imposed for public health reasons at a time when people were dying by the, tens of thousands, and to strike down those regulations that they felt interfered with religious free exercise rights. The same thing is true here. Yes, it's in the area of medical regulation. Yes, that's something that judges don't ordinarily do. But when you discriminate on the basis of sex, as this statute does on it, the court's obligation is to make sure that the state has demonstrated that this ban, a categorical ban, is necessary to further the interest that they assert. That's what the Constitution demands, and there's no exception for medical treatment that says you can discriminate on the basis of sex when you're engaged in medical treatment.
What do you make of Justice Alito repeatedly pressing your ACLU lawyer, Chase Strangio, whether being transgender is immutable?
Well, one of the questions in the case is whether the court should recognize that discrimination against trans people is what we call a suspect class and is therefore subject to more careful scrutiny by the courts. And one of the characteristics that the court has identified in the past as a reason to treat a particular characteristic as suspect, like race or sex or national origin, is that it is immutable. And so he was pressing him on whether transgender status is immutable. But I think, the response to that is that's not the only qualification for whether a particular group is entitled to protection under the Equal Protection Clause. It looks in particular at whether this is a group that has political power, whether it's defined by characteristics that are not relevant to their ability to do most things in the world, and whether they've been subject to historical discrimination. And trans people fit every one of those characteristics. So whether it's immutable or not is debatable, but it is not dispositive.
So I found it odd that Justice Gorsuch, who wrote the only decision involving transgender rights, I believe, to date, didn't ask one question during 2.5 hours. Yeah.
Now, that was odd. And I argued the Bostock case in which, on behalf of Amy Stevens, the transgender woman who was fired from a funeral home when she came out as transgender, and he was very active in that case. I read that as he may be uncertain about where he is in this case, and so he wanted to sit back and listen and hear what other people said rather than speak up, especially because he wrote the Bostock decision. But, the Bostock decision said that when you discriminate against someone because they are transgender, that is by definition, as a matter of logic, discriminating against them because of their sex, treating them differently because of their sex. If that's the case, then certainly a law that on its face says you can get treatment if you do it consistent with your sex and you can't get treatment if you do it inconsistent with your sex should also be subject to heightened scrutiny as sex discrimination. So we'll see how he votes, but he gave no indication today.
Justice Alito kept pushing back on using Bostock, saying it was different.
He did. He dissented in Bostock. But the court doesn't need to rely on Bostock here because, again, when a law on its face says you can do something if it's consistent with sex and not if it's inconsistent with sex, that's sex discrimination. You don't need Bostock. You don't need anything other than the ability to read the words in the statute to see that that is a sex-based classification. And for the last 50 years, the Supreme Court has said that sex-based classifications have to satisfy what they call intermediate scrutiny. It doesn't mean they're all struck down, but it does mean that the state has to come forward and demonstrate that this law and this sex classification is necessary to further an important government interest. The court below did not apply that standard. And really, that is the critical question in the case. Did the court below err by applying a very deferential rational basis test?
Justice, I've never heard this in an oral argument. Justice Ketanji Brown Jackson said, "I'm quite nervous and worried."
Yeah. Well, I think she was reacting to many of her conservative colleagues who seem to be not want to engage with the principal question in the case, whether it's sex discrimination, and instead wanted to engage on whether there's medical uncertainty and what the evidence shows, questions that are really not before them, and with the suggestion that if it's a hard question and if there's medical uncertainty, we ought to accept a law that discriminates on its face as sex-based and accept it as somehow sex-neutral. And, she was concerned because those kinds of arguments were made by the state of Virginia in Loving versus Virginia in defending a law that prohibited interracial marriage. The state said, and she quoted it in court, that there's scientific evidence that supports prohibiting people from marrying across races, and this is not a race classification because it applies to whites and blacks equally. The court rejected that and said, no, when it determines what you can do based on your race, that's a race classification. Same thing here. When the law determines what you can do based on your sex and whether you are acting in a way that the state of Tennessee thinks is consistent with how it thinks people of your sex should act, that's a sex classification.
So the legal pundits and Supreme Court reporters all seem to be saying that it looks like there are 5 votes to uphold Tennessee's ban. Do you agree with that?
I think the 5 conservatives who spoke all expressed some unease with recognizing that this is sex discrimination. It may be that when they go back into their conference and they study the matter further, they may decide, a law that on its face defines what can be done and what can't be done based on whether it's consistent with sex or inconsistent with sex is sex-based, and it would be ludicrous to suggest it's not. It may be that the law could satisfy heightened scrutiny on remand, and they could say, that heightened scrutiny should apply with a softer touch when you're dealing with issues of medical uncertainty. So I don't think it's absolutely clear that our side lost today, but certainly 5 justices expressed some discomfort with ruling in our favor.
This is a fraught time for transgender rights. Donald Trump campaigned on cutting back on transgender rights and possibly a national ban on gender-affirming care. If the justices affirm the Tennessee ban, what does that mean for transgender rights? I mean, is it like a legal turning point?
You're absolutely right that this is a time where one side of the aisle is targeting trans people for political exploitation. For the court to sort of allow that to happen and to say that a law of this type that is facially sex-based is somehow sex-neutral and can be upheld without any searching inquiry into whether the state has a legitimate interest and whether it is furthering it in a tailored way would just open the door to rampant anti-trans discrimination across the country. And as was pointed out at argument, if it's okay for Tennessee to do this, then it would be okay for the entire country to do it, for Congress to do it, and to deny to every trans youth and every parent of every trans youth who has determined that this treatment is medically necessary with their doctors, to deny them the ability to get it anywhere in this country. There would be no bar to such a draconian policy. So I think that would be a terrible, terrible result for trans people.
The plaintiffs, how did they feel after this argument?
Well, I think they look to us, but they also can hear the concerns. And I think, some of the concerns that were articulated were pretty hostile to who they are, to the plight that they face, to the really, really difficult decisions that, parents and families have to make in these situations. And to hear, the justices say, well, it's too complicated, it's too difficult for us to address, even where a statute on its face discriminates on the basis of sex. Very disappointing, very disappointing.
Thanks so much for coming on the show, David. That's Professor David Cole of Georgetown Law. It was a historic day at the Supreme Court as American Civil Liberties Union lawyer Chase Strangio became the first transgender attorney ever to argue a case in the Supreme Court.
On its face, SB 1 bans medical care only when it is inconsistent with a person's birth sex. An adolescent can receive medical treatment to live and identify as a boy if his birth sex is male but not female. And an adolescent can receive medical treatment to live and identify as a girl if her birth sex is female but not male. Tennessee claims this sex-based line drawing is justified to protect children. But SB 1 has taken away the only treatment that relieved years of suffering for each of the adolescent plaintiffs.
Strangio represents transgender youths and their families who are challenging Tennessee's ban on gender-affirming care for minors. But 5 of the 6 conservative justices voiced varying degrees of skepticism about the arguments made by Strangio and the Biden administration. Joining me is Michele Goodwin, a professor at Georgetown Law. The Biden administration was making an equal protection argument here. Tell us a little about that.
Equal protection provides protection for groups of people against state discrimination based on their identity. And it emerged from a period of American slavery where there were distinctions between how people who are of African descent were treated as compared to whites. And this related to matters of education, accessibility to accommodations, where people could live, where and how they could travel, and many other, like virtually every area and aspect of life. And over the last 140 years or so since the ratification of the 14th Amendment, the Equal Protection Clause has been used to protect individuals against being treated unfairly because of who they are, what they look like, these immutable characteristics. Historically, this has been used to combat racial discrimination. It's been used to combat sex discrimination. It's even come up within spaces of discrimination against people because they are gay. And we saw that with the Obergefell decision, which allows now for same-sex marriage and also struck down federal policies that ban same-sex marriage. Now this question has emerged with regard to individuals who are trans, and very specifically in this case, youth who are trans, who are targeted facially by this Tennessee law. And what that means by facially is that embedded in the law itself is a distinction and discrimination in terms of access to medications that are gender affirming, but only for individuals that are trans. So the Tennessee law prohibits puberty blockers and prohibits the use of hormone treatment for young people who identify as trans. It does not do the same for young people who identify as cisgender, and this means that their identity on their birth certificate conforms with what they later see as their identity.
So the Solicitor General and the ACLU argued that this law is sex discrimination, and the Tennessee Solicitor General said, no, what we're doing here is about distinguishing based on the medical purpose and not based on sex.
Right. And what the state has argued is that it has the right to be able to address matters of health and safety for its state, which traditionally has been within the purview of the state. So dating back to 1905, famously in Jacobson v. Massachusetts, where the Supreme Court upheld a local ordinance that mandated vaccination. It did have a carve-out that one could simply pay a fine if one refused to do so, but that case has been understood as providing states authority to impose inoculation and otherwise address public health and safety. What Tennessee wants to do is to use this as a lever against what actually is quite explicit sex-based discrimination, right? So Tennessee is trying to use this as an escape latch or hatch for a law that otherwise, if you substituted race for it, would be intolerable, such as if you substituted religion for it, it would be intolerable, such as if you slipped in, something that was sex-based, but addressing the distinction between cis women and men would be seen as being hostile, such as Tennessee enacting a law saying that hormone treatments will not be available to women because of the state's paternalistic interest in the health and safety of women, but the state believes that men can make these decisions and are equipped to make these decisions on their own. That would be seen as hostile to the 14th Amendment's protection of individuals against unequal treatment.
So the liberal justices seem to agree with that, and Justice Ketanji Brown Jackson actually several times brought up the Loving case as a comparison. But the conservatives did not seem to be buying that argument.
Well, that's not surprising. And one has to understand the atmosphere in which this law comes about, which I think is really important. And I've loved your reporting, June. So I hope that in this article or articles that will be written about it, that it's centered, which is the fact that this is a law which is a creature of recent times. Right? Gender affirming care and even care that involves surgeries dates back decades. So why now with this particular law in just these recent years? The use of hormone therapies in children is also something that is actually not new. Children have received hormone blockers for quite some period of time, for decades. Hormones, the same. This law then and the other nearly 24 others of them that have been enacted in the last 3 years are a reflection of political wins that were kicked up during the last Trump presidency and that have now made their way into this space. And what I mean specifically about that is that there is a Christian fundamentalism that has now made its way within American legislation. We hear this articulated within federal policymaking, and it's now even breached its neck into our courts. And I say that as an empirical matter because, again, technically these issues, these medical techniques have been used for decades. And it has only been within this recent space where we've seen equally attacks on reproductive health, rights, and justice that have been quite extreme. It's within the same period of time that we see these particular laws. Now, to make one other note here, when Tennessee makes its argument that it's intervening as a matter of its authority with regard to health and safety, note that Tennessee is not making those claims with regard to youth that are cisgender. So equally, Tennessee could have just simply said, we don't want any kids to have access to hormones. We don't think that it's a good idea for young boys who are going on the wrestling team to use testosterone. And so we are enacting a policy that says it's not available to any of them. State of Tennessee could have said, if you are a dancer or a gymnast and you're worried about gaining weight with puberty, and so you wanted to use this puberty blocker, we don't think that that's a good reason for it. So we're going to ban puberty blockers and hormone treatment for all kids in the state. But that's not what Tennessee did, although Tennessee could have done that, right? So if Tennessee has a concern with regard to health and safety and what these medical technologies do, they could have said that, well, we see this as being harmful to all children, and we don't see the benefit as being significant enough in order to make a carve out or an exception. But that is not what Tennessee did, and Tennessee would be able to survive a claim that it is engaged in unequal treatment if, in fact, it said we truly are treating all youth in the same way. But that is not what Tennessee is choosing to do.
Coming up next on the Bloomberg Law Show, I'll continue this conversation with Professor Michele Goodwin of Georgetown Law. We'll discuss the implications of this decision. I'm June Grasso, and you're listening to Bloomberg. I've been talking to Professor Michele Goodwin of Georgetown Law. Conservative Justices Samuel Alito, Clarence Thomas, and Brett Kavanaugh in particular questioned the efficacy of gender-affirming care and referred to a point made by Tennessee in its brief that claimed that health authorities in Sweden, Finland, Norway, and the UK found that the medical treatments pose significant risks with unproven benefits. Here's Justice Alito challenging the Solicitor General and asking her if she wants to reconsider what she said about the efficacy of the treatments.
So I wonder if you would like to stand by the statement that you made in your petition, or if you think it would now be appropriate to modify that and withdraw the statement that there is overwhelming evidence establishing that these treatments have benefits that greatly outweigh the risks and the dangers.
I, of course, acknowledge, Justice Alito, that there is a lot of debate happening here and abroad about the proper model of delivery of this care and exactly when adolescents should receive it and how to identify the adolescents for whom it would be helpful. But I stand by that there is a consensus that these treatments can be medically necessary for some adolescents, and that's true no matter what source you look at.
And Justice Brett Kavanaugh asked both the Solicitor General and the ACLU attorney whether they agreed that people can regret transitioning.
Just one point there. You agree that there's some group of people who receive the treatments who later wish they hadn't and wish to detransition. I know you say it's a smaller group. I understand that. I just want to make sure you agree as a factual matter there is some set of people.
I agree as a factual matter, as there is in all areas of medicine.
So it seemed like the conservatives were all about the medicine isn't proven here.
Well, so what's been concerning of this, in this regard, this is not new, but it is of a newer trend that emerged significantly starting in 2010. So starting in 2010, with the emergence of the Tea Party, came its political sweep into office, first at the state legislative level and then within Congress. And with that also later came then the appointment of judges and justices whose points of view, whose methodologies, whose understandings of law seem to be not much distinct from those that were in the legislative space. And I say that as a lead up to the following, which is that there came to be this challenge of what is science? What is health? Can you trust people in the medical field? And it's been deeply alarming, the disregard for medical science. It's been alarming, the deep disregard for learned societies where individuals have to earn the respect of their colleagues based on peer-reviewed scholarship, based on the quality of the scholarship, based on the research that, vetted research. Vetted research now seems to have there seems to be a low respect or limited respect for learned societies and for scientific evidence. And one sees that across a series of cases preceding Scrimetti. So one sees that disregard, let's say in Burwell v. Hobby Lobby, where the Supreme Court conflates contraceptives with abortifacient in an alarming way, in a way that still deserves significant attention and unpacking, where you have for-profit corporations that claim that they have religious perspectives, and those religious perspectives should be respected and honored by the court, which Justice Alito grants. And then where they say they see no difference between an IUD and an abortifacient, they are technically and very significantly different. An IUD will not perform an abortion. They truly are different. And so there is, one sees that also in the Supreme Court's case, the Carhart case, which is another case that involved abortion, where Justice Kennedy, before he leaves the court, says that, women feel regret after having abortions. Technically, we know through empirical research that has involved literally thousands of people who have had abortions that happens to not be true. It is technically just simply not true. But again, this disregard for science, this disregard for health, and the disregard for social science is making its way, as part of what is being espoused legislatively and what we hear coming from the court. Now, on the question, it's not that it's not a valid question or an important question. The problem is how the court refuses to engage in evidence is the problem. And in fact, technically on that question with regard to puberty blockers, what we know is that with puberty blockers, that once they are no longer used, then their effect goes away.
I didn't hear that mentioned in the oral arguments. So
yeah, it's surprising, right? Like that's the whole, like if a puberty blocker doesn't last, if you're using a puberty blocker, let's say someone is 14, 15 years old using a puberty blocker, the impression that is given is that, oh my goodness, now from the age of 15, let's say, when they're using it, or 14, that puberty, that it affects them, they're 20 and they're still, no. Actually, if they used it for 3 months and then stopped, it would go away. Puberty would be onset. And that's worth noting, no matter whether the child is cis or transgender, right? Just the science is important to note and then to be able to adjudicate from there. But when scientific evidence is ignored, such then that the justices ask questions based not on the scientific evidence, but based on an assumption, or that assumption is furthered and makes its way into law, can be dangerous. And in fact, when Justice Ketanji Brown Jackson asked those questions related to Loving, that actually matters too. So it's possible to read the Loving decision as a case that simply involves interracial marriage and a state's law that's wrong-headed, but that bans interracial marriage. If you read the briefs and listen to the oral arguments, then what you know is that there is this hocus pocus with regard to medicine that comes in there too. If the state is alleging that if interracial marriages are tolerated and allowed, there will be the term mongoloid children emerges in the briefing, that there will be children with disabilities that are born from these unions that will overwhelm the state. This is the same argument that's used in 1927 in Buck v. Bell, one of the most egregious cases in the United States, where the court sanctions compulsory sterilization, again, under this notion that there will be people who are unfit to live in our society. And those unfit people are going to burden our society for all of their unfitness. And Justice Holmes says, better than to let them starve for their imbecility, society can prevent those who are manifestly unfit from continuing their kind. It has nothing to do with health and science, and yet health and science is all around it, playing this role that is actually not credible.
About half the states have these kinds of bans. If the court upholds this ban, what happens in the other states?
Those bans, many of them are in effect. There are some that are not in effect, but it means that those that are not in effect can go into effect if the court upholds this ban. And that also means that parents in those states who want to provide care for their children may end up leaving those states. They may move out of those states. They may travel to other states for their children to get the care that they believe that their children need and deserve. So one might see parallels that one saw in relation to reproductive health matters, where states enacted abortion bans and people have had to travel from, states that have bans in order to get the health care that they desire.
So nice to have you on the show again, Michele. That's Professor Michele Goodwin of Georgetown Law.
And that's it for this edition of the Bloomberg Law Show. Remember, you can always get the latest legal news on our Bloomberg Law podcast. You can find them on Apple Podcasts, Spotify, and at www.bloomberg.com/podcast/law. I'm June Grasso, and you're listening to Bloomberg.